It's an honor and privilege to introduce the first speaker, Honorable Miss Justice Manjari Nehru Kaul, Judge, Punjab and Haryana High Court. Honorable Miss Justice Manjari Nehru Kaul was enrolled as an advocate in the year 1987, and while in active practice in Punjab and Haryana High Court and Supreme Court of India, Honorable Ladyship was appointed as Deputy Advocate General Punjab for 2 years from 2007 to 2009. Thereafter, on her appointment as Additional Advocate General Punjab in 2009, she handled various important cases for the state of Punjab. Besides being a keen debater and orator, Honorable Ladyship won accolades in sports as well. Honorable Ladyship was elevated as the Judge of Punjab and Haryana High Court on 29th October 2018. May I request Honorable Ms. Justice Manjari Nehru Kaul, Judge, Punjab and Haryana High Court, to enlighten us on the aspects of child custody and guardianship, issues and challenges.
Good morning, everybody. And before I proceed, wishing you all a very happy Makar Sankranti. Yes. Now, the topic of discussion is child custody and guardianship, which you all know has evolved with the passage of time. Now, am I on this thing?
Yes, ma'am.
Okay. The pioneers of our constitution emphasize the importance of the role of a child and the need of the child's best development. The manner in which a child is brought up, you will agree, has a bearing not only on the family, but even on the society as a whole. And every nation, whether developed or developing, without a doubt, links its future with the status of the child. Now, childhood holds the potential for positive change in the society, and neglecting the children would not only result in a loss to the child and his future, but you will agree it would amount to a loss to the society as a whole as well. The primary source of social interaction of a child is without a doubt the family. When the family structure is not stable, it adversely affects the child and does stunt the emotional development in particular of the child. Such instability may be brought out because of various reasons. Maybe a lot of reasons, socioeconomic reasons, but since we are talking about child custody and guardianship, I would say that, if there are matrimonial differences between the parents, there is acrimony between them, then, the instability of the child, particularly of children of separated parents, divorced parents, is writ large. No doubt the parents do exercise their legal rights through divorce. However, it is the child who is the most affected by the decision of the parents. A child is at the risk of being traumatized. He does face panic, fear, even shame, guilt, and anxiety, because he is exposed to a wavelength of emotions, including isolation and loneliness. And it becomes apparent that in litigation between the parents and families for custody, it is the interest of the child and child alone which has to be considered and protected. So it is in this background that I would now proceed with the discussion. See, today's discussion focuses on child custody, especially the evolution of child custody jurisprudence and the practical challenges which are faced by the courts in determination of child custody. At the outset, it would be most pertinent to point out that the terms custody and guardianship are being used interchangeably. However, there is a very fine and subtle difference between both. The concept of custody is related to physical control over a person or a property, and the concept of guardianship, on the other hand, is much broader and is described as a bundle of rights, which is akin to the concept of trusteeship. A guardian is a trustee in relation to the person of a person for whom he is to be appointed. Thus, the position of a guardian is more onerous than of a mere custodian. However, in the present context, barring a few exceptions, this distinction, this differentiation has blurred. Since parents are the natural guardians, the question of making any differentiation does not arise between the two concepts. However, it may arise when the person seeking custody is a third person, that is neither of the parents. Maybe the mother is no more, and there is we do face all these cases do come up before us. There is a dispute between the maternal grandparents and the on one side, and the father on the other side, who may have remarried. Then there may be a case wherein both the parents are no more. Now the child, there is a dispute between the maternal grandparents, maternal side of the child, and paternal side of the child. So, a lot of challenges are being faced by the court in this regard. Now, if we start with the evolution of child custody in India. Parents patri. Now, in the ancient times, it was the king who was considered parents patri, that is, he was the parent of his or her country. Even the custody rights of the minor children were vested in the state, in the king. And though there were no custody laws back in existence at that time, even Manu Smriti describes that the king shall protect the property of the minors until he attains the age of majority or until he returns home from his teacher's house. With the passage of time, there was a shift in the custody of the minor children from parents patri to natural guardians. It shifted from the king to the natural guardians, though the custody rights did shift to the natural guardian due to the prevalent inequalities governed by the paternalistic values. The father at that time also was considered to be the sole guardian of the person and property of the child. the authority of the father in every aspect of the child's life, including his or her conduct, education, religion, maintenance, was considered to be absolute. Well, though it has evolved with the passage of time, but initially the women did suffer from the shackles of patriarchy, and as such, the mothers had no authority over the children in the absence of any independent legal status, because of their identities being merged with that of their husbands upon their marriage. But when dissolution of marriage through divorce became possible, and the mother began to have an independent legal existence and residence, their claim to have the custody of the children also began to be recognized by the courts. We are all well aware that our laws have been greatly influenced by, we have a great deal of British influence, because that is but natural. We remained under colonial rule for almost 200 years. Indian law on the subject thus was substantially influenced by the policies and judicial rulings in England. The position in England also initially emphasize the preferential treatment of father in cases of child custody. However, with the passage of time, two developments aided in the dismantling of paternal preferential right over children even under the English law. First, in a number of judicial decisions, the courts claimed that parents' petri jurisdiction, the higher parental authority of the state, to supersede the natural guardianship of the father and award custody depending on what promoted the welfare of the child. And secondly, through a series of legislations, the British Parliament shifted the emphasis from paternal rights to the welfare of the child and conferred equal legal status to the father and the mother as well in determining guardianship and custody. Now, the introduction of statutory law on custody by the British in India, the Guardian and Wards Act, was enacted by the British, which remains in force even till date. And it was the first legislation in India on the subject of guardianship. Though England subsequently did grant rights to both the mother and the father, nevertheless, this act continued the legacy of common law, granting preferential right in guardianship and custody of children in India. Post-independence, however, post-independence, subsequent amendments were brought in the act, and a balance has been struck in favor of both the parents. Now, coming to the personal laws in India, even though the Guardian and Wards Act remained in force, however, the Indian population was, to begin with, initially governed by their personal laws, predominantly Hindu and Muslim law. Now, as far as the Hindu law is concerned, Hindu religion did not recognize the concept of custody, as it was considered that it is the father alone who could look after the welfare of the child, and after his death, after the death of the father, it would be the mother who shall be given the custody of the child. In the joint Hindu family, the Karta was responsible for the overall control of all the dependents and management of their property, and therefore specific legal rules dealing with guardianship and custody were not thought to be necessary. Coming to Islamic law, on the other hand, the father is the natural guardian, but interestingly, the custody vests with the mother until the son reaches the age of 7 and the daughter reaches the age of puberty. Islamic law is the earliest legal system which provided for a clear distinction between guardianship and custody, and also for explicit recognition of the right of the mother to custody of a child. Now, with the passage of time and as the society progressed, the need for codification of the personal laws was felt. And it is in this background and for this purpose, the Hindu Minority and Guardianship Act of 1956 came into force. Under this act, the expression Hindu covers, as we all know, covers Buddhists, Jains, Sikhs within its ambit of its definition. Therefore, the custody of a Hindu child is governed by the Guardian and Wards Act 1890, read with Hindu Minority and Guardianship Act. Now, this section 6A of the Act, what it provides for, that in case of a minor, unmarried girl, the natural guardian of the father, and it is after him the mother, and the custody of a minor who has not completed 5 years of age shall ordinarily be with mother. Now, the expression of after him, that is after the father, which appears in section 6A1 of this act, has been a bone of contention and a topic of discussion amongst the legal fraternity, since on the face of it, it does give a preferential right to the father. Now, it was in this background, the constitutional validity of 6A was challenged in Geeta Hariharan versus Reserve Bank of India as being violative of the guarantee of equality under Article 14 of the Constitution. The Supreme Court considered the import of the word after and examined whether, as per the scheme of the statute, the mother was disentitled from being a natural guardian during the lifetime of the father. Now, in Geeta Hariharan, the Supreme Court observed that the term after must be interpreted in the light of the principle that the welfare of the child, welfare of the minor is paramount, and the constitutional mandate of equality between men and women was considered. The court held that the term after in section 6A should not be interpreted to mean after the lifetime of the father. But on the other hand, it should be taken to mean in the absence of the father. So there is so the distinction was made out that after the father does not mean upon his death, but in his absence. Now, the court, the Apex Court further specified that absence could be understood as temporary or otherwise, or total apathy of the father towards the child, or even the inability of the child by health reasons, ailments, or some XYZ reason. So absence would include a lot of things under it. Could be maybe the father has been missing for some time. He has gone missing. Maybe he was in the army and he's been held as a prisoner of war. Or it could even mean he's lying in a coma. So there are a lot of things. He's in a coma. The wife has deserted him. Maybe as per the husband's family, the wife deserted him after he fell ill, after he fell into coma, of course. But the paramount consideration in each and every case would have to be the welfare of the child. Now, the Law Commission of India, on the other hand, to remove this anomaly, in its 133rd report, had recommended amendment of Section 6A to constitute both the father and the mother being natural guardians jointly and severally, having equal rights in respect of the minor and his property, so as to remove the preferential position given to the father. Even Hindu marriage, if coming to the Hindu Marriage Act, Section 26 authorizes the courts to pass interim orders in any proceeding under the Act with respect to the custody, maintenance, education of minor children, but in consonance with the wishes of the children, in consonance with their wishes. Now, what have been the judicial trends? The judicial decisions initially were passed considering the welfare of the child principle as well as the rights of the parents. Thereafter, the welfare of the child assumed primary importance, and through a catena of decisions, it was settled that the primary focus shall be the best interest of the child rather than the rights of the parents. Thereafter, the courts have consistently followed the principle that it is not the welfare of the father, or for that matter, the welfare of the mother, that is to be considered at the time of deciding the custody of a child. It is the welfare of the minor and the minor alone which has to be considered and would have to be of paramount consideration. Now, development of this welfare principle, there have been a lot of development has taken place through judicial decisions. The statutory right of the parents were thereafter put on the back seat whenever it was felt that it would adversely affect the welfare of the child. Now, for example, in the context of Guardianship and Wards Act, the Honorable Supreme Court in Rosie Jacob versus Jacob, it is 1973, Volume 1, SCC 840, held that the object and purpose of the 1890 Act, that is Guardian and Wards Act, is not merely physical custody of the child, of the minor, but due protection of the rights of the health of the ward, his maintenance and education. In considering the question of the welfare of the minor, due regard has to be given to the rights of the father as natural guardian. But if the father cannot promote the welfare of the child, it was held by the Supreme Court, he can be refused such guardianship. It was also further observed by the Supreme Court that merely because there is no defect in the personal care and of the father and his attachment for his children, which of course every normal parent has, it cannot be a ground to grant him custody simply because the father loves his children and he's not otherwise shown to be undesirable. It does not necessarily lead to the conclusion that the welfare of the child would be better protected and promoted by the father by granting him the custody of the child. The court also, Supreme Court also observed that children, I'm sure you all have gone through it, the children are not merely chattels, nor are they toys in the hands of their parents. Absolute right of parents over the destinies and life of their children has in modern social conditions must yield to the consideration of their welfare as human beings so that they may grow up in a normal, balanced environment, balanced, wholesome, healthy manner to be useful members of the society. And the guardian court, in case of a dispute between the mother and the father, it is expected of the guardian court in such like situations to strike a just and proper balance between the requirements of the welfare of the minor children on one hand and the rights of their respective parents over them on the other hand. In Surinder Kaur Sandhu versus Harbaksh Singh, the Supreme Court held that the father no doubt is the natural guardian of a minor son, but that by itself cannot supersede the paramount consideration as to what would be conducive to the welfare of the minor. Similarly, in Maushmi Moitra, the Supreme Court went on to observe that while determining the question as to which out of the two parents, as to where the interests, welfare of the child would be better protected, the first and paramount consideration would have to be the welfare and interest of the child and not the rights of the parents under a statute. There is no dispute that the provisions of law pertaining to the custody of a child as contained in the Guardianship Act, in the Hindu Minority Guardianship Act, and Guardians and Wards Act also holds out that it also says that the welfare of the child is of predominant consideration. In fact, no statute on the subject can ignore or obliterate the vital factor of the minor of the welfare of the minor. Now, it is I've given you all these examples, the various judicial pronouncements, which I've just spelled out, detailed. So one thing is abundantly clear, that while deciding upon the question of a minor child's custody, it is not to be seen from the angle of the parents alone, but it has to be seen from that of the child also. It is not to be seen as to which out of the two parents has a better right to custody, but yet again, it has to be seen from the point of view of the child as to where he would be better placed so as to ensure his overall healthy growth and welfare. The said principle applies equally to all cases, irrespective of the religion or personal laws of the parties. as has also been in a number of judicial pronouncements, it has also been observed by the Supreme Court that it is not the negative test that the father is unfit, that the father is not unfit or disqualified to have the custody of his daughter or son, which would be relevant, but it is the positive test that such custody would be conducive and would be for the welfare of the minor. And this is what is the material consideration. And it is on that basis that the court should exercise the power to grant or refuse custody of a minor in favor of mother, father, or any other guardian. Now, coming to the right of a mother to have custody of a child, ordinarily the mother is supposed to have the custody of a child below 5 years. A very poignant, it would be, I would refer to a very poignant observation made by Bailey in Habeas Corpus, Volume 1, page 581, wherein he states that the reputation, I think. The reputation of the father may be as stainless as crystal. He may not be afflicted with the slightest mental, moral, or physical disqualifications from superintending the general welfare of the infant. The mother may have been separated from him without the shadow of a pretense of justification, and yet the interest of the child may imperatively demand the denial of the father's right and its continuance with the mother. The tender age and precarious state of its health makes the vigilance of the mother indispensable to its proper care, for not doubting that paternal anxiety would seek for and obtain the best substitute which could be procured, yet every instinct of humanity unerringly proclaims that no substitute can supply the place of her whose watchfulness over the sleeping cradle or waking moments of her offspring is prompted by deeper and holier feeling than the most liberal allowances of nurses' wages could possibly stimulate. Inverted commas closed. Now, however, it's been very beautifully detailed here in Bailey's. However, I've read that out. However, no presumption can be made only on the basis of this, that mother is best suited to be a guardian over the father or somebody else. The Apex Court has emphasized that it cannot be assumed that the mother is naturally a better custodian for the child or is better placed to respond to the diverse needs of the child. The situation, however, is different in the case of child born outside wedlock. The prevailing position is that it is the unwed mother who possesses primary custodial and guardianship rights with regard to her children, and the father is not conferred with an equal position merely by virtue of his having fathered the child, as has also been held by the Supreme Court in one of its judicial pronouncements. Now, the next question would be of custody of the child to a third party. the emphasis on the welfare of the child at present is such that even if the mother or the father is alive, but if the welfare of the child so demands, they both can be denied the custody of the child, and a third person may in in that in those circumstances be granted the custody and guardianship of the child. Now, in Tarun Ranjan Majumdar, this is 1991, AIR, Tarun Ranjan Majumdar versus Siddharth Datta. It was held by the Honorable Calcutta High Court that even if a child is in the custody of one who has no legal right thereto, and the welfare of the child is being well looked after, reasonably looked after in a manner in which it should be, the legal guardian cannot claim an order of return or recovery of child merely on the strength of his legal right of financial soundness. Better financial resources of either of the parents or their love for the child may be one of the relevant considerations, but it cannot be the sole determining factor when it comes to the custody of the child. It is in such like situations, in such like circumstances, that a heavy duty is cast upon the court to exercise its judicial discretion judiciously in the background of all the relevant facts and circumstances, and yet again bearing in mind the welfare of the child, which I have already said has to be the only paramount consideration. Now, what are the parameters of the welfare principle? It would be apposite to point out here that the principle of the welfare of the child has been repeatedly hailed, and as I've also just even earlier, I've just been repeating that welfare of the child, welfare of the child. Now, but what includes within this ambit of welfare of the child? What does this expression welfare of the child mean? Because it has not been defined anywhere. The expression would have a different scope depending on the peculiar facts and circumstances of each individual case. It is only through a catena of judgments, which I referred to earlier, that the guiding principles have been formulated to assist and aid the courts of law, the court of laws, in determining the welfare of the child while granting custody and visitation rights. Now, the word welfare has been used in Section 13 of the Hindu Minority and Guardianship Act, and it must be construed in its widest sense. Now, the welfare principle of the child is actually, it is aimed at serving twin objectives. First instance would be to ensure that the child grows and develops in the best environment. The best interest of the child has been placed at the vanguard of family custody disputes, keeping in view the optimal growth and development of the child, and has primacy over all other considerations. The right of the child is based on individual dignity, which also finds foundation to the right to life as guaranteed by the Constitution. Now, the second justification behind the welfare principle is the public interest that stands served with the optimal growth of the children. Child-centric human rights jurisprudence that has been evolved over a period of time is founded on the principle that public good demands proper growth of the child, who are the future of the nation. Now, a few considerations must be kept in mind, must be borne by the courts during the adjudication of child custody. Like, for example, the wishes of the parents. For example, there may be, and we do come across cases wherein the parents voluntarily give up the custody of their child. That is one such consideration. If one of the parents gives up the custody, obviously it has to be handed over to the other parent. Now, wishes of the child also. Of course, when we go to the wishes of the child, his age has to be seen. Is he able to form an intelligent judgment? So that also has to be considered. Next, the majority caregiver until the point of litigation, interaction and relation of the child with the parents, his siblings, and other members of his family. Then the mental and physical health of all the other relevant individuals who could be considered for being given the custody. And besides age, even the gender of the child has to be taken into account. Another aspect is moral character of each parent, because we do come across cases wherein maybe the father has been convicted for some heinous offense, and there could also be the mother also could be convicted for say, for example, for immoral trafficking. In that, even in such like conditions, you know, all these relevant factors have to be minutely considered before the court can decide on handing over the custody of the child to the parent. Now, love, affection, and emotional relation between the child and each parent. Maybe now there may arise a situation wherein the mother is involved in, say, some heinous crime, and she's inside, she's been convicted, or she's facing trial. There's nobody at home, and the husband, on the other hand, he has remarried, or maybe he's not been in touch with the child. The child has no love, affection, or emotional relationship with such parent, with this father. Then in that case, yet again, the courts have to be very, very cautious in deciding upon the custody. Then there are other relevant factors which have to be seen, and maybe in such like circumstances, you may then think of a third person as a guardian who would be best suited to take care of the child. Could be his maternal grandparents with whom he has been in constant touch. Now, parents plan for child care and rearing. child care abilities and also the capacity of the parents. Now, such considerations are never static and they cannot be squeezed in a straitjacket. Therefore, the court must keep certain things in mind while deciding upon the question of the welfare of the minor child. That is security and safety of the child, and more so when it is, say, the child happens to be a 12, 13-year-old girl. Comfort, happiness, conducive environment, enabling the wholesome growth of the child, that is his physical, psychological, moral, ethical, intellectual growth, better health, which would include physical, mental, as well as emotional health, best educational attainment, and stability, which of course is very important to enable such growth in life. A lot of practical challenges are faced, like they may, in the case of the conduct of the parents, there may be previous litigation, history of litigation, their behavior during the litigation, and their future parenting plans also must be kept in mind by the court while adjudicating upon custody issues. The court is expected to scrutinize the behavior of the parents during litigation. This is a very relevant factor. Because on account of matrimonial differences, on account of the animosity which the parents have for each other, we do come across in most of the cases that the parents do try and influence, poison, tutor their children, as a result of which the children they may be inclined towards one parent, but since they are staying with another parent, they are forced to spit venom against the other parent. So it is here wherein the courts have to play a very constructive role. And it is herein that the child, though it's not a very happy place, no, it's not a very, the child being called to the courts, you all know it's not a very happy place to be in. But then in custody battles, more often than not, the child is subjected to objectification and treated as an asset to be acquired. Parents, as I said, they pollute the child against the other to use the child as a leverage in the litigation. They lure the child by offering money, gifts. Now, I'll just give you a small example. This was very recently, and you would have also seen that more often than not, it is the affluent class, the educated class, when we are handling custody matters pertaining to people who come from the so-called affluent class, educated class, where it is most ticklish to decide the custody issues, because the parents are affluent, the children are torn between the two, they are poisoned, and they are offered lollipops, expensive gifts, expensive holidays, and it is then that the role of the court comes into is most important. Now, just recently, I had this case wherein the mother was a successful doctor, father also working in an MNC, doing very well. Two boys, one son was about 12 years old, the other son 14 years old. About a year back, their father was granted visitation rights. Divorce proceedings are pending. There were photographs where the sons, they enjoyed the company of the father. And the father was given 7 days visitation rights. The father traveled all the way from Chandigarh to be with the family in Gurgaon. Of course, he was in a hotel where the children would come. And there was a video was taken, and the child were given 4 hours every day, and they were in a very conducive, very happy. there were WhatsApp chats where the children told the father, "We hope to see you tomorrow. We hope our mother doesn't stop us from coming to you tomorrow." And for 3 days, everything went off well. Fourth day, the children did not come. Of course, the contempt proceedings were initiated. That's a different thing. Now, yet again, the father came before us that this year also for winter vacations, I want to visit my children. Now, within 1 year, the things were changed. The two sons who were so happy, the documents were there, the photographs are there, videos were there. They were so happy in the company of their father. This time round, when I interacted with them, they had taken a U-turn. They said, "No, we don't want to go." So when I questioned them, I said that last time you were very happy. Of course, you also know that, you have to make the children very comfortable. I said, last time you were very happy. You went around, you were in the hotel, and I can see the video, and you were posing with your father. So, you know what the children said? The children said, "Well, our father had forced us to take those pictures and to smile and laugh and play with him, because in case we did not do that, he would not give us his property. The father is a landed man." Now, can you beat it? On the face of it, it was a case wherein the children had been tutored by one of the parents. So it is in most of the cases, at least I have seen, and I'm sure you would also agree, it is the educated class who are their children's own enemy. They are the ones who pollute them, and that is how it is going on. Now, I think I have taken a lot of time. Is it? I've taken a lot of time, right? I think, ma'am, I did not realize it's been quite a long time.
A very engrossing session,
No,
ladyship.
I don't know whether it was engrossing or not, but I just continued. I've just been told my researcher that, "Ma'am, you have already exceeded your time." I'm so sorry for that.
No, ladyship, you still have time. You still have time. You can continue.
Sure?
Yes.
I only hope I am not. I have time.
Yes, ladyship, there are a few questions also, in case you want to know about those.
Yes. Can we just? It's all right. I don't want to waste the time. Yes. Yes.
There is one question about the joint custody of the child. I mean, they want to know what has to be kept in mind while granting joint custody of the child.
Okay. Now, joint custody in the sense, if they are, now again, the question would arise whether the parents are separated or some proceedings are underway. There are a lot of aspects, a lot of things which have to be even, that has to be considered. And joint custody, yet again, it would be like the age of the child. It would again come down to the age and gender of the child. Because now it could be a case wherein, say, the mother is say, in a place like Chandigarh, right? And the father, a similar matter came up before us when I was in the matrimonial roster. The father was in a place like in a remote village, though a landed man, and the mother was in Chandigarh. Now, the children wanted to go to both the parents. They wanted to be in the company of both the parents. But herein, the children were studying in a good school in Chandigarh, whereas admittedly, the father also conceded that he was somewhere in Nakodar side. It was a remote village, that there weren't many good schools over there. But he still wanted, he said, "No, I cannot stay away." And the children also wanted to stay with both the parents. In that case, of course, see, we have to see the other relevant factors. In case if it is a school going child, he is used to a particular environment, he's going to a good school, don't you think it would be very harsh on the child to be uprooted, and the mother also, who is working here, and to expect the child to be taken to Nakodar or vice versa. In this case, again, I feel it's the counseling which would we would have to resort to counseling and see if better sense can prevail upon the parents, because if it is in the same city, say it's in the same city, then also it is not very healthy, because see, the psyche of the child is affected. She knows, she or he knows that I have two homes, and my mother is staying, say, in Mohali, father is in Panchkula. It is not a very conducive this thing, and middle path has to be taken out. And then again, we have to join the distance between the two parents, Panchkula and this thing. Maybe over the weekends, we can grant them joint, we can give them visitation rights. Or because joint custody, it does not, at least I don't feel it works out in the end, and a middle part has to be followed in such like cases.
Ladyship, as you've rightly pointed out, that welfare of the minor is of paramount consideration, and that has to be kept in mind every time in deciding each and every case. There's another question. Am I permitted to ask?
Yes.
Thank you, Ladyship. In this case, the child is living with his paternal grandparents after the death of his father. The mother remarries. The grandparents are keeping the child quite well. So the officer wants to know whether the custody should be handed over to the mother who has remarried, or should it be retained by the grandparents?
How old is the child? And how long
has not been mentioned in the question.
See, even if the mother has remarried, can she be deprived of her child? How can a mother be deprived of a child? It's very unfortunate that she lost her husband, the child lost his father. But then again, why should a mother be deprived of her child? Yes, of course, the paternal grandparents have a right over their grandson. And if the grandparents are if they are taking care of the grandchild, and the mother is not very keen, then of course there's no harm if the grandparents are allowed to retain the custody of the child. But in case the mother has remarried, and it appears that the child is going to be kept well after by the stepfather also, I don't think the child should be kept away from the mother. Of course, with visitation rights, frequent visitation rights with the grandparents, because we cannot lose sight of the fact. Of course, the age of the grandparents will also have to be taken into account. I'll tell you another case. This happened, this came up before us. This was over there, the husband, the father had died in an accident. The lady, the mother of the child, she remarried. The child was about 4 or 5 years of age. Everything was fine as long as the girl had not got married. Once she got married, and see, the lady has a right to, that's very unfortunate. A young girl lost her life, lost her husband. She got married. And that is where the problem started. The grandparents did not give the custody of the child to the mother. And what happened then thereafter, the mother came before us. She said, my former parents-in-law, they are ailing, they are aged, they are the only ones staying there. Of course, I have my brother-in-law and his family, but brother-in-law and his family have their own children. So my child is being neglected, is going to be neglected. In such like this thing, we handed over the custody of the child to the mother, after, of course, taking all the other factors into consideration, because one of the parents-in-law, mother-in-law, was then laid up in bed with a hip fracture. Father-in-law was also not keeping well. The brother-in-law he had his own family. They said, it's all right. She said that I want my child now. So we gave the custody of the child to that mother, of course, with visitation rights, as and when the uncle and his other relatives wanted to visit the child for festivals, marriages, we gave that. Of course, it was only after counseling the parties. So all these, it cannot be very, case specific. It depends, it varies from case to case, circumstances to circumstances. Yes.
Leadership, there's another question.
Yes.
Whether a wife facing trial under Section 306 IPC for abetting suicide of her husband is entitled to custody of her children who are residing with paternal grandparents.
No, in that case, when there are allegations there, unless and until she earns an acquittal or whatever, as long as that, and if the children have been residing with the parents-in-law, even prior, then it is a no. No. It should normally, ordinarily not be done, because the mother is already facing trial. She's already behind bars. Over here, at least they are growing up in a family atmosphere with the parents-in-law and all of them. And then, of course, see, again, it would boil down to the antecedents, the character of an individual of the parent. It could be now in this case, it is 306. She's facing trial under 306, or maybe she's convicted also. Or maybe in the case of a husband, he's facing trial under 376, POXO, or whatever. Moral character also has to be one of the considerations, because that in turn would have to be taken into consideration while deciding the paramount welfare of the child. No, in such cases wherein there are heinous crimes like 376 or POXO, immoral trafficking, like maybe it's a case wherein, say, maybe even 302, the mother is, along with her paramour, has allegedly murdered her husband. And in that case also, I don't think, I would not give the custody to the mother. The custody should be retained if the child has been living with his paternal grandparents. Well, he's more comfortable. He has seen them. He's being brought up by them. So his custody, he should not be uprooted from there and handed over to the mother side of the family or to some third person. We have to see where he would be. And as it is, he would be totally traumatized because firstly, the father is missing from the scene now, and the mother is inside. We don't, a child, once the child is about 5-6 years old, if we think the child is oblivious to what is happening in his life, we are mistaken. Maybe he's not expressive, but he does realize that something is amiss, and he would have also been sensing that the father has died, the mother is inside. So he should be kept away and given a very normal environment, and which in the circumstances would always be where he has been residing with his paternal grandparents.
Ladyship, what would be the position if the child is below 5 years?
Now, below 5 years also, if supposing it's the lady who is an accused, the mother is an accused, and she is already behind bars. Now, the question would be, where was the child residing? With whom was he living at the time of the alleged occurrence? If he was living in a joint family setup, well, it would be much better that he's retained in the same joint family setup. If supposing there was already a dispute going on between the parents, say, and the child had not been living with the, like you said, 306, maybe the allegations are that on account of the mental torture, whatever, etc., meted out to the husband by the accused wife, he has ended his life. But in this case, the child had been living with the wife in her paternal home. In that case, uprooting the child from the custody of his maternal grandparents just because the mother is an accused would also not would be criminal, and just taking him and putting him in the with the paternal grandparents with whom he has had no interaction. So that's one aspect that the mother is facing trial, or maybe she's been convicted. But we cannot traumatize the child. He has already lost his mother. His only source of strength or comfort level is with his nana nani. It would be totally unfair and traumatic for the child to be uprooted and thrown in the house of his paternal grandparents with whom he has hardly interacted, or with whom he does not have the same comfort level. So, it has to be case specific, and it has to be considered in the light of each and every individual case.
There are no more questions, Ladyship. Thank you, Ladyship, for sharing your rich knowledge with us.
It was a pleasure.
I'm sure we are all enriched.
Thank you so much. All the best. Thank you.
Thank you so much.